Hello, I'm Gary Finklea from the Finklea Law Firm in Florence, South Carolina. I would like to speak with you a little bit about what happens when you become delinquent on your car payments. I get a number of calls in my office regarding these types of matters, and hopefully the information I share here today will be beneficial. First, if you become delinquent on your car payment, the creditor cannot repossess your car until they send you a notice of right to cure. That's required under South Carolina Code Annotated Section 37-5-111. Now, that notice of right to cure gives you 20 days to bring your account current, pay all applicable late fees and other charges assessed under the terms of your note. Once you bring that payment current, it's as if a default never occurred. However, if you don't make that payment, then the lender has the right to repossess your car. The biggest misunderstanding or misconception, however, is that the notice of right to cure only has to be sent once during the financing contract. Therefore, if you were late back in 2009 and then 2012 you're late again, so long as they sent that notice of right to cure back in 2009, they do not have to send another one back in 2012. When a repossession occurs, the first thing that I ask my client to do is bring in a copy of the notice of right to cure, and if one wasn't sent, inquire as to whether one was sent earlier, previously, whether it be prior months or prior years. And oftentimes the consumer forgets about that prior occurrence, and we get in litigation and find that one was actually sent, or at least purportedly sent. Now, once a vehicle is repossessed, the consumer protection laws still provide the consumer with some rights. First of all, the consumer has the right to redeem the collateral anytime by paying the note off in full or having it refinanced. Now, of course, practically that's hard to do. But the second biggest pitfall that I see, and this is from a lender standpoint, is that lenders fail to dispose of the property in a commercially reasonable manner. Once the car is repossessed, what is supposed to happen is that the lender is supposed to sell that car either at an auction or through a private sale. Regardless, the sale has to be performed in a commercially reasonable manner under the Uniform Commercial Code. That's Title 66 of the South Carolina Code. Once the vehicle is sold, the consumer is generally responsible for a deficiency judgment. A deficiency, of course, is the difference between what was owed on the car and what it brought at sale. Therefore, if the car sells for $10,000 and $17,000 was owed on it, the consumer is responsible for a $7,000 deficiency judgment. Now, that's a tough pill to swallow, and many consumers don't understand that, but that is the deficiency judgment. Another common pitfall that I see is consumers say, well, I just gave the car back, and they thought it was going to be even Steven with the lender. Well, that's not the case. Unless you have a written agreement with the lender that they're going to waive the deficiency judgment for you voluntarily surrendering the collateral, you are still responsible for the deficiency judgment. Now, there's a number of other issues and pitfalls that all consumers should be aware of if you find yourself in this situation. And not only that, quite frankly, car dealers, particularly the buy here, pay here car dealers, fail to send a notice of right to cure, fail to sell the collateral in a commercially reasonable disposition. Generally, the consumer is not harmed if they don't have any equity in the vehicle. However, one of my recent cases, the consumer had placed $4,000 down, and the buy here, pay here lender failed to dispose of the collateral in a commercially reasonable manner, failed to hold the sale, just had a private sale to consumer, failed to give the defaulting buyer the benefit of her down payment. Of course, we're in litigation in regard to that. If you have any questions concerning this, please feel free to call the Finklea Law Firm at 843-317-4900. You can find us on the web at www.finklealaw.com, or please feel free to email me, gfinkley@finklealaw.com. Thank you.